Welcome, everyone, to Creating a Family. Talk about foster, adoptive, and kinship care. I am Dawn Davenport. I am the host of this show, but also the soon-to-be ex-director of the nonprofit creatingafamily.org. And just a warning to everybody, we are not a warning, I guess, a shout out. We are now on YouTube. So if you want to see us in person, pop over to our YouTube channel under Creating a Family, and you can watch us as well as listen to us. Today, we're going to be talking about the Hague Treaty on Intercountry Adoption, as well as all the laws that are backed up in the United States to support that treaty. We will be talking with Kelly Dempsey. She is a partner in the firm Fox Rothschild, and she specializes in adoption and assisted reproduction. She is also a fellow in the Academy of Adoption and Assisted Reproduction Attorneys, which means she is a true expert in this area. And perhaps, as I told her, her crowning qualification is that she is an adoptive parent through both international adoption as well as domestic adoption. So welcome, Kelly, to Creating a Family to help us better understand the Hague Treaty on, it's actually the full name is the Hague Convention on the Protection of Children and the Cooperation in Respect to International Adoption. It is sometimes referred to as a convention, but for those of us in the international adoption field, we call it the Hague Treaty. So today we will most likely always be referring to it as the Hague Treaty. So welcome, and can you give us some background? First of all, the United States signed this back in '94, but we did not actually enter into force in the United States until 2008. But give us some background, like why was an international treaty even needed, and why did it take so long for us to implement?
So the Hague Convention has been around a long, long time, and it was born of the UN Convention on the Rights of a Child. The United States has still not signed that treaty. We're one of the last in the world to have failed to sign that. But the Hague Convention was intended to create sort of a reliable system for intercountry adoption where all of the different countries who were performing incoming and outgoing intercountry adoptions could plug in with a similar framework and agreed upon process to streamline the experience for all the players and the participants, the families and children. The idea was that it would remove some of the obstacles and it would promote transparency, trust, and cooperation and collaboration among the partner countries. It was intended to promote both permanency for children and protection for children. So it was intended at its highest level to be a treaty that served vulnerable children around the world.
To provide permanency. Mm-hmm.
To provide permanency, that's exactly right.
And so I guess had a dual function, I suppose, and one would be the best interest of the children. And the second one, I think that it was one of the underlying goals was to eliminate fraud. And the reality was that it was the Wild West at the beginning when international adoption first began. And this treaty, and the reason it had to be a treaty is that we needed both the sending and the receiving countries, and it's not just the United States, but other receiving countries, and certainly other sending countries, including the United States, which also is a sending country.
That's right.
To be on the same page as far as the elimination of frauds, and it set up a framework in order to eliminate fraud and to provide permanency for children. So let's talk about some of the key elements of the treaty as it was drafted and as we, as a country, a signatory to it, as one of the participants for the treaty.
Sure. The treaty started by sort of enunciating its goals, and those are the things we've just talked about: the promotion of permanency, the protection of the child in the process, and collaboration and cooperation between the countries. That's a tongue twister.
Yes.
And then the mechanism by which that was going to happen was going to be a designated entity in each of the countries known as the Central Authority. Mm-hmm. And the Central Authority was supposed to be the clearinghouse for all of the information about the adopting parents and the identified child. And it was to verify both the suitability of the parents to adopt and the eligibility of the child to be adopted, and to create and foster a sense of trust among the countries that everything was being done in the best interest of the children, honorably, ethically, and above board. The notion was that governmental involvement would remove it from the Wild West, right? That there would be a place in the government. And I would just want to footnote that the place we chose in the United States is the Department of State, which is our diplomatic house and largely has law enforcement functions around the world. And every other country chose their health and human services or child welfare houses. We are the only country to have made the decision not to host our central authority in health and human services. But the creation of central authorities around the world was a novel concept, and it created a requirement that countries enact new laws and requirements and regulations,
Create
not
a
just
new
ours,
entity.
but everyone.
And often create a new entity because it may be housed in a department but there was nothing that was in that department that was set up to be the central authority.
That's exactly right. And then, in addition to the creation of the central authority, it promulgated a process by which all of the countries would agree to proceed with an international adoption. And it's a number of factors and layers and steps, and each country gets to determine who is eligible to adopt and who is eligible to be adopted. So that is not outlined, but there is a broad framework for how those decisions are made, and more importantly, when those decisions are made. So the Hague process was something that everybody had to adhere to, and running afoul of that process can be fatal to a Hague adoption.
Absolutely. And we're going to get to the process in just a minute. But before we do that, something else that the Hague Convention set up was an approval of accredited adoption. They call it agencies, not entities. I was trying to remember what it is.
That's right.
Adoption service providers, ASPs. Yeah. And that was new as well. So you had to be, if you're adopting under the Hague, you have to work with an accredited or approved adoption agency or adoption service provider. And then there were a lot of requirements set up for what those adoption service providers had to provide, what type of training had to happen with their employees, what type of reporting, what type of record keeping. So there was a whole host of things set up for them as well.
That's exactly right. And that is also unique to the United States. There are other countries who have similar delegated authority, but the Department of State is our central authority, but we have delegated many of the central authority functions in the United States to adoption service providers, international adoption agencies, and then regulation and oversight responsibility to an entity that was created specifically for the purposes of providing oversight to agencies to make sure that they follow all of those rules and requirements.
And there's a transparency requirement. They have to disclose their fees. I think that has to be in writing. They have to disclose total cost or estimated total cost, things such as that. Let me interrupt this interview for just a moment to tell you, or actually to remind you, that we have another podcast called Weekend Wisdom, where we answer your questions. In order to answer your questions, we need you to send them to us. So please send us your questions about adoption, foster care, or kinship care to info@creatingafamily.org. And we will select the ones we're going to answer on Weekend Wisdom, and you can listen and get your question answered. So now back to this interview. So when we're talking about, we've talked about the Hague, and we've also gone down and talked about some of the implementing laws created in the United States in order to function under the Hague. Then, if we're speaking of the receiving country, the United States, we also have to talk about the Immigration and Nationality Act, INA. Why do we have to talk about that? We've got this whole convention and all these laws that were implemented to allow the convention, the treaty to be function here in the United States. Why do we also now have another law that we have to talk about, the Immigration and Nationality Act?
An international adoption is a bifurcated process. So you really think about it in terms of two discrete legal paths that have to be pursued. And the first is the adoption process itself, and that is happening in the foreign country largely and under the laws of the foreign country. But once that has been completed, the family wants to bring that child home to live in the United States. And so the Immigration and Nationality Act does the second process, and that's the immigration of the child. So the INA created the legal mechanism by which children can come home once they've been adopted through a Hague adoption process. So it's sort of a part two, but equally rigorous, equally important, and equally complex portion of the process for families.
Otherwise, if the adoption and the vast majority of international adoptions, the adoption itself, the becoming the legal parent of the child, happens in the country, the country of the child's birth. You could be the legal parent, but you have to also be able to bring the child, immigrate the child back to the United States. And it's not just a matter of saying, I have adopted this child. Therefore, I have the right to bring this child back. You then have to jump through the hoops set out by the Immigration and Nationality Act. There are two basic ways to get children into the United States that have been either adopted or you're trying to adopt. One, these are not necessarily the best names, but one would be called the Orphan route, which is also known as I-600. So that's the Orphan route. And that's in contrast to I-800. Guys, we're talking law, so we're going to have a lot of these numbers and things like that. Yes. And that's called the convention route, or the route under the treaty. Convention is just another word for treaty. All right. Can you explain the difference between the two? And then under each one, it can give us an idea of what is required.
Yeah, it's that's going to be a lot, so bear with me. I feel like I'm getting ready to get really in the weeds. The I-600 process, the orphan process, applies when the sending country or the child's country of origin, the place from where you are adopting your child, is not a party to the Hague Convention. So if you are dealing with a non-Hague country, you will pursue the orphan path to immigrate your child. The orphan path in the United States has a lot of the same protections and requirements of the Hague path. And that is true because we passed another federal law called the International Accreditation Act, which said that adoption service providers had to be compliant with the Hague regardless of the country of origin status. And so the exact process isn't the same, meaning the steps you go through and the sequence you comply with those steps. But for the orphan process, essentially, once the child has been adopted and the parents have been deemed suitable, they seek to immigrate the child by filing the I-600A. There are not as many requirements. We'll distinguish the Hague process shortly, but the I-600 process requires that the petitioners, the adoptive parents, prove to USCIS that the child is an orphan. Orphan doesn't mean that the parents are dead necessarily. Orphan means that the child is living in institutional care or outside of the care of the family of origin through some enunciated mechanism. The mechanisms are created in the Code of Federal Regulations, and those are abandonment. When I hear the word abandonment, I don't think of it as the way it's been defined in the federal law. Abandonment under federal law means that a birth parent has voluntarily surrendered the child to an orphanage, signed a relinquishment, and said, I choose to sever my parental rights forever. We also have desertion. Desertion is more of the case of a foundling or a child who's entered institutional care or court custody because the parents have failed to act. Abandonment requires an act. Desertion is the failure to act.
Would that also include some of the same reasons that children enter foster care here, which is the inability of the parents to, and the state stepping in saying you can no longer parent because you are neglectful or you're abusive or you're not providing safety or whatever.
Yes, it can. We have another prong under the orphan status known as severance, and that is when the parental rights have been terminated through a judicial process
Uh-huh.
with due process provided, notice, and an opportunity to be heard to the parents. We don't see that very much because most foreign countries, non-Hague foreign countries, don't have as robust a system in
Right.
place to satisfy that requirement.
Mhm.
And death, disappearance, if a child's found and we have no idea from where the child came or who the parents are, there has to be a search, for example, by a competent authority to locate the parents. And then a court must find that the competent search failed to find the family of
Mhm.
origin.
And they have to have records to show that they attempted to search what they did. All that has to be transparent.
Has to be transparent, has to be documented, and has to be, in many cases, contemporaneously documented with the events that are being recorded. For example, a police report that is created 2 years later to satisfy an immigration requirement is not as reliable as a police report that was created on the day the search was done.
Interesting.
And
Yeah.
in many non-Hague countries, again, the systems aren't as robust. And
Yeah.
that is the logical fallout of a country that doesn't have the resources to build a central authority and enact new laws, but they have these very complex requirements in order to immigrate the child.
Mhm. Let me pause here and mention you mentioned USCIS, and let me just say that is Citizenship and Immigration Services. I just wanted to, when we talk about the INA, the Immigration and Nationality Act, that is the entity that we are working with.
That's right. They're the ones who make the initial determination about suitability of parents and eligibility of children.
Mhm. What if the child has a single parent? There's the other parent is either absent, abandonment, or dead, but the child does have a living parent. Is that child eligible for adoption under the orphan route of which is the form is called I-600?
That's right. Yes, a child with a living parent and in that living parent's care and custody can be deemed an orphan under US law and immigrate to the United States. However, there are two caveats to that. The first caveat is that the parent must willingly and unconditionally release the child for adoption and immigration to the United States. What that means in almost all of these cases is that parent is going to be brought into the US Embassy and asked to confirm that they understand they may never see their child again, and be asked to confirm that they agree to allow the child to go to the United States and to be adopted and have their rights terminated. The second piece of that test is that the sole or surviving parent is incapable of providing care in accordance with the local standard. That sounds pretty simple, but whether a parent is capable of providing care under the local standard requires a really complicated examination of the circumstances, both in that country and region, but also in that particular family structure. So if a family lives below the poverty line, but so does everyone else in the community, poverty alone may not be sufficient to prove they're incapable of providing care below the community standard. If they have a medical condition, terminal illness, for example, that is more likely to prove incapable of providing care. But the test isn't, are they going to be incapable of providing care one day? Are they incapable today of providing care for that child? And so we see this happen, this analysis happen frequently in cases, particularly in family settings, where an adoptive parent's sibling has lost a spouse, or an adoptive parent's parents have taken care and custody of a child because parents have been deceased or are suffering from addiction, or any sort of
Yeah.
complicated family
What we
structure.
would call kinship adoption. The aunt and
That's
the
right.
uncle or the older sibling is living in the United States and they want to adopt their brother or their niece or their nephew, whatever. Exactly.
And a desire to adopt your relative does not mean that it will be possible. I spend a lot of time talking to families who want to provide a better opportunity for their nieces and nephews. And I have to explain to them why it's probably not going to happen under this rubric.
It's the hard part of your job.
We jokingly say that it's the dream killer. I'm just like, I have to tell people it's not going to be possible. It's too bad.
All right, so we've talked about that is the orphan route. Also, let's just quickly mention that the child has to be, you have to submit the form, which is the I-600A, before the child's 16th birthday.
That's right.
So that's just want to throw that's another complicating factor for the orphan route. Now, we're talking about immigration under and after the adoption has been finalized under the Immigration and Nationality Act. We've talked about the two routes. One is what we call the orphan route, and the form is the I-600A. Now we're going to be talking about the other route, and that is what's called the convention route, or the route under the treaty, and the form is the I-800. So you sometimes hear it referred to the I-800 route. Okay, take us down that route.
This route is on its face simpler and objectively faster. That's one thing I wanted to note. USCIS, the immigration authority who processes the cases, notes on the website processing times for each phase of this adoption process. And for the I-600A, which is the suitability determination of parents, it is currently listed as of today at 6.5 months. If you juxtapose that with the I-800A, that is at 4.5 months. So it's moving a little faster. Here's where it really makes a big difference. When you are filing to have the immigration of the child approved, the I-600 is what you file, and that is taking 28.5 months, so over 2 years. What I think is important for families to understand is there is a child waiting in a foreign country for this entire time. This is not an abstract process. This is a real family trying to come together. 28.5 months is the reported time frame right now. You compare that with the I-800 process, and that is coming in at 4 months. So huge difference.
Huge difference.
Now,
huge difference.
What I think is important to note is it's a little bit apples to oranges. And that is because the I-800 comes far sooner in the process than the I-600. So let me walk you through the I-800 process, and then I can explain what I mean by that. Okay. The first step in an I-800 adoption is to find your primary provider or your adoption service provider. The adoption service provider has to be what we call Hague accredited, has to be approved by the Department of State and their delegated entity to conduct intercountry adoptions.
And that is not an easy process to go through. Let me tell you, it is the agencies that are providing this service, they have to go through a lot of hoops in order to do that. Go ahead.
Yeah, and it is expensive and time consuming. And when the US implemented the Hague in 2008, there were 200 adoption agencies around the United States providing international adoption services. Today, there are fewer than 25. So there has been a really, really drastic reduction. And agencies that used to be really full service, if you wanted to internationally adopt, you had hundreds of agencies to choose from. Now you may have one or none because agencies have to be authorized by the US government in each country they seek to offer services. So knowing that you want to adopt internationally isn't enough. You have to know which country you want to adopt from, and then you have to find an agency working in that country who will approve to take your case. So that's step one, find your agency. Step two is have your home study completed. That home study process is a really rigorous examination of your suitability to adopt. I say that it's a look under the, open kimono is how I describe it to families. It's a warts and all examination of who you are and how you intend to parent a child. It looks at your upbringing, any difficulties you've experienced in life and how you've overcome them. It looks at your finances, your medical history, perhaps your psychological health.
And some of this is dictated by the placing country, the country of the child's birth.
Absolutely.
There's differences. They may accept, some will accept no, there are weight requirements for some. There are whether or not you could be taken an antidepressant. There's just different, each country has their own requirements, and that has to be included in the home study. And then let me throw out, because we are a training entity, creating a family is, it's not just in addition to the open the kimono and examine you and your family. There is also a component of let us train you on the things that will help you be a better parent to this child. So that's also part of the home study process. Not to derail you on your process, I'm very thankful you're going through it, but I just wanted to throw out that that's part of it as well.
There is an educational component to make sure that the family has anticipated and acknowledged the inherent trauma and difficulty of pursuing an intercountry adoption. What I commonly say is the best day of your life will also perhaps be the worst day of somebody else's. And the ability to allow both things to be true is really important in the successful integration of a child into a family. So the home study process takes typically several months. It requires federal, state background checks, abuse and neglect registry checks, reference letters, employment letters, tax returns. So once your agency is finished with that assessment, they'll prepare a report. It's often many, many, many pages long, and it will conclude that you are approved to adopt a child of a certain description. And that description is typically going to be around age, gender if there's any restriction, race if there's any restriction, and then special needs. And so the job of the agency is to determine what types of children could be placed in your home successfully to avoid disruption or dissolution or further trauma to the child or to your family. Once that step is completed, you then will submit that document along with other basic documents about who you are, including your citizenship status, your marriage status, proof of any prior divorces, etc., to USCIS under the I-800A. That is that suitability determination. So the I-800A then, once processed, and again, we said that's currently around 4.5 months, will generate an approval. That approval goes to your adoption service provider and to the National Visa Center. The National Visa Center will communicate it to the embassy, and USCIS will communicate it to your agency, who will then communicate it to the central authority in the country of origin for the child you're seeking to adopt. That allows the central authority to prepare a match for you, to identify a child that is within the parameters for which you've been approved, and to propose that an adoption be made for a specific child. Many families currently begin the process knowing the child they want to adopt, not knowing necessarily having spent time with, but many relative adoptions, many identified children in advance. Maybe they've hosted, maybe they've seen them on a website. And so this matching process is not of an unknown child necessarily. It can be, but it doesn't have to be. But what happens by the central authority in the sending country is the preparation of a dossier, a lot like the adoptive parents dossier, home study, that will give you the social medical history of the child, the chain of custody history of the child. Where are they living? What is their institutional care situation? When did they come into care? Why? Also, you will get basic medical information that may or may not be all that reliable. And an interesting thing that the Hague requirement imposes in these dossiers is an examination of what we call the subsidiarity requirement. And the subsidiarity requirement is a hierarchy of permanency for children that requires the central authority demonstrate that other options, in-country options, were examined and eliminated as not in the best interest of the child. There's not a domestic option that will serve this child's needs as well as this intercountry adoption. And that has to be articulated in this report. This report is known as the Article 16 report. And it is created by the entity, the central authority, and then it is shared with the adoption service provider, who then shares it with the family and gives the family the opportunity to accept or reject that referral.
Okay. So they have to be able to show that there is not an option available in country for this child. And it's not that they're not at that point looking to say that the in-country option doesn't have to be whatever I'm using air quotes here, equal to the, in ways, there's just that they have to show that they have tried to find a suitable placement in country.
That's right. And typically that requirement is met through the passage of time. Child's been institutionalized for 6 months. No family has come forward to adopt. That is how they eliminate domestic adoption as an option. In relative cases, they may waive, unless there is a suitable kinship alternative, they would prefer a family-based relative placement anywhere other than placing the child with a stranger in country. Once the referral is accepted, the Article 16 is approved by the adopting family. The adopting family then goes back to USCIS to seek approval to move forward with an adoption. So they submit the Article 16 report along with the verification by their adoption agency that it is true and accurate and complete to USCIS under the cover of the I-800 form. The I-800 form, again, as opposed to the I-800A, is focused strictly on the eligibility of the child to adopt. USCIS then takes, right now, reporting it 4 months, to review that dossier, to do any verification needed, any investigation needed through its embassy in country. That often is authenticating the documents, interviewing anybody who they feel they need to talk to verify the information. One of the things I can say at this point is that the reason that investigation process is streamlined under the Hague is because the system is built on trust. The US is not supposed to look behind the work of the central authority or to second guess the conclusions of the central authority unless there is a reason to believe that there's been a breach of protocol, a break in the process, some evidence of fraud or misconduct. So really, if the birth certificate is authenticated by the foreign government, that's it. You believe the contents of the document. And that is different from the I-600 process, where we don't have that layer of trust. And so there is a full field investigation of every case. And that is, in large part, the difference in the processing times that we see. So once the authentication and approval has happened at USCIS, there is an Article 5 letter issued. The Article 5 letter is the family's permission slip to travel to the foreign country and to complete their lawful adoption process in country. Now, that is not the end of the road, but it is the moment they've all been waiting for, right? It is the happy, happy day. And so once the Article 5 is issued, the U.S. adopting parents can take legal custody. The converse of that is so important for families to understand. You cannot take custody of a child until you have the Article 5 letter. We see families in the United States often getting ahead of themselves, particularly where they have dual nationality. So if they are also citizens of the foreign country from where they're adopting, they may circumvent this process, go and get an adoption order, and then try to shoehorn themselves into a Hague adoption. It cannot be done. Because if you adopt prior to the issuance of the Article 5 adoption, you have destroyed the integrity of the Hague process. And it is very unlikely that you'll be given a waiver by both central authorities to proceed with the immigration. And instead, what is very likely is you will be required to start again. You will have to have your adoption decree nullified, set aside, and then you're going all the way back to the beginning. That is really expensive, really time consuming, and really heartbreaking for families. So,
and children, yes.
Yeah. Absolutely. To undo the legal family that you've built so that you may bring a child to the United States would be a bitter pill for sure.
Yeah.
So once the Article 5 is issued and you've traveled to the country to accept custody, then you adopt the child, and then you apply for your immigrant visa. And so the I-800 approval is USCIS saying, we will allow this child to immigrate if you complete the adoption and secure an immigrant visa. So you still have two very important steps left, but they are intended to be streamlined at this point, meaning without a second examination of all of the eligibility requirements.
Mm-hmm.
The adoption process is governed by the laws of the foreign country, so they're going to be different in every foreign country.
Totally.
And it's also very possible that you won't actually be getting an adoption order. There are many countries that issue custody or guardianship orders with the intent that the placement will be supervised for a period of time once you've entered the United States prior to finalizing the adoption. Mm-hmm. Now, that doesn't mean you can't bring the child home. It just means you have more to do when you get here. Mm-hmm. So we'll come back to that. The immigrant visa process, once you've completed your adoption, the family will go to the embassy for their visa application and interview process. The child will have had to have a medical exam and certain vaccinations proven to the embassy, but all of that can happen relatively quickly by a licensed provider authorized by the US government to provide those medical exams and vaccinations. Mm-hmm. It's not a local doctor. It's not just any local doctor. It will be a local doctor, but one who has entered into a contract with the US government to meet certain standards. We call them civil surgeons. Once the adoption's complete, you filed for the visa, you've completed all of the eligibility requirements for the visa, which include an interview, proof of the adoption or guardianship, the medical exam. If the child is over the age, it's different in every country, but if you're adopting a child who has 16, for example, you may have to get a police report to show that they have no criminal history. And then you get your visa. The type of visa you get for an I-800 is known as an IH3 if you've completed the adoption in country, or an IH4 if you will be required to complete the adoption in the United States. Mm-hmm. My office has a silly saying that we use for these to keep it straight, which is IH3 home free. Means once you get home, your child will be a U.S. citizen by operation of law. Your certificate of citizenship will come in the mail, and you are done. Mm-hmm. IH4, you must do more. And for those children, they will enter the United States. They will not be U.S. citizens. Instead, they will be green card holders, legal permanent residents. And they must be adopted in the United States in order to secure citizenship. So it's very, very important for families to understand the visa type and the continuing obligation they may have. It's also important that agencies make sure they understand. But I get a lot of calls from families whose children have just been told they can't have a driver's license or student aid because families failed to follow through.
Getting their U.S. citizenship. And it's important for families to know if they're adopting. And this, let me just pause here to say that one thing to keep in mind is your adoption agency is very familiar with this process and is going to be your guide through this process, because as Kelly is describing it, it is overwhelming, but you have a professional and a support network that is going to be walking you through. But it's really important to know that if you're adopting from a country that just gives guardianship, that in fact, you have to then apply for citizenship. And you must do that for your child to be a citizen, to be able to get a passport, to be able to enter colleges. And I mean, certain colleges, you are not a citizen otherwise. So anyway, it is so important. And you're sick and tired of paperwork at that point. And it's easy to think, I've got a 5-year-old. What am I? I got time in the future. You won't get around to it in the future. You will just aren't going to. You must do it then, immediately. Okay, that was my
Absolutely.
point for the importance of U.S. citizenship papers.
That's right. just to tack on to what you've said, I also recommend that even if you're home free, meaning even if you've come home under the IH3, I think there is real value in completing either the domestication of your foreign adoption decree or a readoption in the state where you live. The reasons are many, but my top three are that your child will get a state-issued certificate of foreign birth. So they will have a document that looks like everybody else's document for the rest of their lives. It eliminates othering at its most basic level. And I just think that's really important. The second reason is it cures any defects in the underlying adoption process. It prevents anybody anywhere from ever being able to challenge the authenticity or validity of that foreign adoption decree. And then the third, and most important, at least for me, is that it allows you to get easily and quickly additional copies of the paperwork. Most adoptive parents come home with a single adoption decree and a single birth certificate for their child. And if something happens to those documents, you are gone. They cannot be replaced. But if you have completed the domestication process in the United States, you can go to your courthouse at any time and get additional copies. And as the mother of adopted children, I can tell you I need those documents regularly, particularly as my kids have become driving age, college age. Those sorts of life events shouldn't be stymied by the failure of people to read the foreign language, understand the documents, or the parents to access the documents. So I just think it's super important for families to not stop all the hard work and effort at homecoming. There's just a little bit more to really secure your children's future.
Cross that finish line. You can do it.
That's right.
Yeah. Before we continue, I have a favor to ask. We are dependent on you, our listeners, our dear and kind listeners, for your star reviews and your comments. That is how any of the podcasting platforms recommend podcasts. They base it on how many star reviews you have and how many comments you have. So please do us a favor, and whatever platform you are using, hop over to that and give us a star review, or if you're feeling kind, give us a written comment. Let me quickly go through how to do that on the top ones. First of all, we are on YouTube now, and to leave a comment on YouTube, you just go below and just leave a comment. We read all of them. To give on Apple, to leave a star review or a comment, you go to the Creating a Family podcast page, which is where all the episodes are listed. And you go to the bottom and scroll to the bottom, and then you will see where you can put a star. You click on the number of stars, and then you can click on, there's a thing that says to leave a comment or to leave a review. On Spotify, to leave a rating, a star rating, you can go on the podcast page itself, which is where all the episodes are listening for the Creating a Family podcast. And that's where you could put a star rating. To leave a comment on this particular episode, you go to wherever you're listening to this episode, and below on the show notes, there's a place for you to write a comment. So we would be very appreciative if you do that. Now I'll let us get back to talking with Kelly about the Hague Treaty. All right. So is there any other part? Have we given the basic outline for adopting from a Hague country?
We have.
Okay. That would be the I-800. Is there anything that's different for when we're adopting from a non-Hague country?
Yeah, so in a non-Hague country, you're not required to go in those specific steps, meaning suitability determination, submitted to the central authority, referral received, eligibility determination by USCIS. On the orphan side, the I-600 side, really you can do any of it in any sequence. And you can even do a concurrent filing, meaning your suitability to adopt and the eligibility of the adopted child to immigrate can be determined all at once by USCIS. So there is no requirement that you take things in this ordered process. We talked about the adoption before the Article 5 letter being fatal to the Hague process. There's no such bar on the non-Hague side of the adoption. It is much more relaxed in terms of sequencing and protocols. However, the ways that it's the same, are really important. And that is, you must have a licensed agency here in the United States to serve as your primary provider. You must pass the same scrutiny checks with your home study and suitability determination. So it is not any less rigorous in terms of the proof you must give in order to be able to ultimately immigrate this child. It's just that how you get to that finish line can look a little different. And as I mentioned earlier, it's going to take a lot longer. And that is because of the basic lack of central authority systems in place in non-Hague countries.
Is it more likely that the U.S. government would not approve because they have to do the investigation on their own to determine suitability, eligibility for adoption? Is it more likely that you're going to run into problems where the child is not eligible?
Absolutely. We see a much, much higher denial rate in non-Hague countries. We also see a lot more allegations of fraud. We see many, many more requests for evidence or notices of intent to deny. Those are issued once you've submitted your I-600 or I-800 or I-600A or I-800A. Those are documents that are issued by USCIS to give you an opportunity to address the problem that they have identified. So if you receive a request for evidence or a notice of intent to deny, the US government is saying, you have a problem in your case, and they're going to give you one chance to fix it. And so we see that far more often in non-Hague countries than we do in Hague countries.
And your adoption service provider, i.e. your adoption agency, which you must have, is also your guide through this process, I assume.
They are your guide, but I also would suggest that families may want to build a bigger team at that moment, because an immigration attorney is going to be really important to helping you resolve the specific technical issue that's been identified by the US government as a bar to bringing that child home. It is often about the insufficiency of the evidence to prove orphan status or the identity of the child. And I'm not sure that it's a fair expectation to place on adoption service providers to be able to navigate the legal requirements in that way.
Would it also be helpful? This is probably a rhetorical question because I know the answer. Would it also be helpful for the immigration attorney to also understand adoption law? Because it is an entirely different beast from the traditional immigration.
It is. Yes, I think it's really important that anybody on the team be familiar with a variety of laws and requirements. I think everyone needs to have a working familiarity with the foreign country's adoption laws, the treaty, if, for example, the Hague Treaty is involved, what those regulations require, and then also the immigration laws for the child. And the immigration laws for adopted children are completely different than they are for non-adopted children or any other relative. And it's a very different process. So yes, you want to find someone with some international adoption expertise, I think, to assist you in navigating the path. And it's not necessary if everything's going well. I don't want anyone to misunderstand what I'm saying, that an immigration attorney ought to be involved in every international adoption, because that's simply not true.
In fact, they would just get in the way of your adoption service provider, your adoption agency, who, especially if it's an adoption from a Hague country, I mean, there is a very set process. They walk this road all the time. They don't need that. They don't need a hand in the pie.
That's right. I say that's exactly right. And it will just increase your costs, increase your timelines. You don't need an attorney unless you need an attorney, and you'll know.
Right. And as far as how to find an attorney, that is a unique specialty, I will say. It's someone who is versed in both immigration law and adoption law, and specifically international adoption law. First of all, your agency might be able to recommend somebody. Also, the Academy of Adoption and Assisted Reproduction Attorneys, I know of a number of fellows of that academy that have that specialty. Is there a way to search on they go by Quad A, Academy of Adoption and Assisted Reproduction Attorneys. Is there a way to search for both immigration and international adoption experience on the website, Quad A website?
I think you can only search for international adoption on the Quad A website, but those are the same thing. International adoption, any attorney who's participating in international adoption is really doing
It's going to have both
work.
Okay.
Yeah.
Perfect.
And that should yield, I think probably 7 or 8 attorneys around the country who are doing this work with any frequency.
Mm-hmm. Right. And you don't have to choose someone who is local to you in this case.
That's right.
And quite frankly, most attorneys now are doing everything via Zoom and online anyway. So it really isn't just keeping that in mind. It's you don't have to choose somebody local. And quite frankly, this specialty you're not going to find. It will be rare if you live someplace where you have a local person. But it might be good to use them if they're local, just because you can meet with them if you want to do that.
It's handy.
It's handy.
I would also just want to say that the same is true for adoption service providers. It's more important to find an ASP that you like, trust, and that's got experience in the country that you seek to adopt from than having someone local to you.
I'm so glad you said that. Yes, it does not have to be local to you. So yes, that's a very good point. Now, when you finalize your adoption, once you return home, right, you may have to if you're under the IH4, but if you're under the IH3, you don't have to. But as Kelly has mentioned, there are some distinct advantages. But honestly, any adoption attorney can do that. And that does have to be somebody who is licensed in your state.
That's exactly right.
Let me interrupt one more time to do a shout out to the Jockey Being Family Foundation and their support of both this podcast. Yay, thank you. As well as their support of our free online education that we have. There are 15 courses on there. They are free and they're just terrific. And you can use them for continuing ed if you need it, but you can also just use it to be a better parent. You can get them at bit.ly/JBF support. That's bit.ly/JBF support. And now back to Kelly. All right. I want to give out some websites for people if they're looking for more information. Kelly, before I do that, is there anything else you would like for folks to know about the Hague Treaty on Intercountry Adoption and the implementing laws that allow us to bring children from abroad home?
I would say that as critical as I've been, I still believe that some of the best resources are found on the USCIS website and the Department of State website. I visit the Department of State website every single day to look at country-specific requirements or to learn more, but it's a great way to see if the Hague is in effect in a particular country and who may be authorized to help you.
And let me give those websites.
Oh, I'm sorry. Did I steal?
No, not at all. You said it much better than me. And I agree with everything you just said. The U.S. State Department website is travel.state.gov. And then when you get to that, click on international adoption. It's in the horizontal menu, and that's where you need to go. For the USCIS website, Citizenship and Immigration Services website, it is uscis.gov/adoption. Or honestly, you can just type this into your search engine and you're going to be able to find it that way as well. There are also sections on the U.S. State Department website that give, and we will include links to those in the show notes, that walk you through much of the process that we discussed, and including links and things. So I will link to that and the course notes here for everyone to be able to utilize. Thank you so much, Kelly Dempsey, this is not an easy subject to talk about because it is complex, but it's something that you have to know if you are wanting to be a permanent home for a child who was born and you want to bring them to the United States to raise them and as your child. So thank you so much, Kelly Dempsey, for helping us today to understand, like I said, a complex issue. We truly appreciate it.
It's my pleasure and honor. So thank you so much for inviting me.